A federal judge defied the Supreme Court, looked directly at a binding Supreme Court ruling, understood exactly what it said, and did the opposite anyway. And last week, the Supreme Court responded in a way that almost never happens. They did not just overturn the lower court, they publicly dismantled it, line by line. The majority opinion specifically called out the lower court's legal errors, its failure to follow Supreme Court precedent, its improper interference with an ongoing election, and its fundamental misunderstanding of constitutional principles the Supreme Court had already clearly established. This is Alabama's redistricting case, and the shockwave it just sent through every federal courthouse in America is enormous. I'm Michael, 5 years in constitutional law and firearms rights, and this is Firearms Law Advisor. What just happened tells you everything about where the Supreme Court stands on lower courts that think they can ignore binding precedent. Before we go any further, subscribe to Firearms Law Advisor right now and turn on every single notification. This case is heading back to the Supreme Court for a full merits ruling, and every development matters. When new orders drop, you need to know within minutes. Hit that subscribe button, hit that bell, and after you subscribe, drop Firearms Law Advisor in the comments right now. I personally go through every single comment and will find yours and thank you directly. Let's get into what just happened and why it matters far beyond Alabama. To understand why this Supreme Court order is so significant, you need to understand what the lower court actually did. This entire battle centers on the Supreme Court's landmark ruling in Louisiana versus Callais, a decision that dramatically reshaped how federal courts must evaluate vote dilution claims under Section 2 of the Voting Rights Act. The Supreme Court made three things explicitly clear in that ruling. First, lower courts must separate race from politics when analyzing redistricting maps. Second, courts must honor traditional districting principles like community of interest and avoiding incumbent pairings. Third, courts must stop treating a state's partisan layout as automatic evidence of racial discrimination. Following that ruling, the Supreme Court vacated a previous decision against Alabama and sent the case back down with strict orders to apply the new framework. The lower court looked at those instructions and, instead of following them, issued a ruling blocking Alabama's 2023 map entirely. They forced the state to use a court-ordered special master map, a map drawn by judges, not by the elected legislature, not by any democratically accountable institution. Alabama went directly to the Supreme Court on an emergency basis, and late last week, the Supreme Court responded. Drop your state in the comments right now. Are you watching from Alabama or another state where federal courts have overridden legislative redistricting decisions? I personally read and respond to every single comment on this channel. Here is where this order becomes genuinely extraordinary, because the Supreme Court did not just grant the emergency stay, they took the time to explain exactly what the lower court did wrong, in detail, publicly. The majority made three devastating findings against the lower court. First, the presumption of legislative good faith. The lower court had treated Alabama's legal disagreement with prior court orders as proof of discriminatory intent. That is not how constitutional law works. State legislators are entitled to a presumption of good faith when drawing their maps. The lower court presumed bad faith. The Supreme Court said that was wrong, flat out wrong. Second, the botched Callais framework. Under the Supreme Court's framework, if challengers want to strike down a state map, their alternative map must perform just as well as the state's map across all legitimate objectives. The challengers here completely ignored Alabama's valid interest in preserving its historic Gulf Coast communities of interest and avoiding incumbent pairings. The lower court ignored those failures. The Supreme Court did not. Third, the Purcell Doctrine violation. This is one of the most fundamental principles in election law. Federal judges have no business altering election procedures on the eve of an ongoing election. The lower court tried to argue that keeping the court-drawn map in place was simply more convenient for election officials. The Supreme Court rejected that logic entirely and added something important. While federal courts must remain cautious about last-minute changes, sovereign states themselves are free to decide whether adjusting their own maps is in their own interest. That is a statement about state sovereignty that goes far beyond this one case. Which politician in your state do you think has been most aggressive about using federal courts to override elected legislatures on redistricting and election rules? Name them in the comments right now. The three liberal justices, Sotomayor, Kagan, and Jackson, dissented. And their dissent is worth understanding because it reveals exactly what the stakes are in this case. Sotomayor accused the conservative majority of injecting chaos into the election cycle, arguing that restoring Alabama's 2023 map forces election officials to reassign hundreds of thousands of voters on short notice. justice. She accused Alabama of continuous gamesmanship and argued the state should not be rewarded with an emergency stay. But here is what the dissent's argument actually reveals when you strip away the rhetoric. The liberal justice's position essentially requires states to permanently accept a map drawn by unelected judges, because changing it now would be disruptive. Think about the constitutional principle embedded in that argument. If a court-drawn map runs long enough, the state loses the ability to restore its own legislative map. The longer judicial interference continues, the more permanent it becomes. The majority rejected that reasoning, and they were right to. The disruption caused by restoring a legitimate legislative map is not the state's fault. It is the consequence of a lower court's unconstitutional interference in the first place. What is your honest reaction when a federal court ignores binding Supreme Court precedent and the state has to spend years fighting through emergency applications just to restore its own legislative map? Who is actually causing chaos in the election system? Type the lower court or the state in the comments. I want genuine constitutional analysis from this community. Here is the realistic picture of where this case heads from here, because the emergency stay is not the final word. Alabama is now implementing its 2023 map, the one its elected legislature drew, for the upcoming congressional elections. State election officials are moving immediately. The court-drawn special master map is gone, but the stay is temporary. To keep it permanent, Alabama needs to file a certiorari petition asking the Supreme Court to take up the full merits of the case using the Callais framework. That petition is almost certainly being prepared right now, and here is what makes that petition significant. When the Supreme Court granted this emergency stay, they included language stating that Alabama has shown a high likelihood of success on the merits of its constitutional claims. When the Supreme Court uses that specific language at this procedural stage, they are signaling exactly how they intend to rule when the full case comes before them. This is not over, but the direction is unmistakable. Do you think the Supreme Court will take up the full merits of Alabama's case and issue a final ruling that permanently limits lower court authority to override legislative redistricting maps? Type SCOTUS takes it or case settles before that in the comments. I want serious predictions from people following these constitutional battles closely. Here is why this redistricting case matters directly to gun owners and Second Amendment advocates. Because the constitutional principle at the center of this ruling extends far beyond maps and election districts. The Supreme Court just publicly rebuked a lower court for defying binding Supreme Court precedent, for ignoring the legal framework the Supreme Court had already clearly established, for substituting its own judgment for that of elected legislators without constitutional authority to do so. That is the exact same pattern gun rights organizations are fighting in Second Amendment cases right now. The Ninth Circuit openly stating it will interpret Bruen as narrowly as possible. Lower courts creating legal tests for Second Amendment cases that exist nowhere else in constitutional law. Courts upholding gun restrictions without any founding-era historical analog, in direct violation of the Bruen framework the Supreme Court established. When the Supreme Court publicly dismantles a lower court for that exact behavior, it sends a message that every federal judge in every circuit must hear. You do not get to ignore binding Supreme Court precedent because you disagree with it. You do not get to create your own legal tests for cases involving constitutional rights. And when you do, the Supreme Court will call it out, by name, in writing. That message matters enormously for the Second Amendment cases currently working through courts that have been openly resistant to the Bruen standard. Here's the bottom line. The Supreme Court just drew a definitive line. Lower courts that defy binding precedent will be publicly rebuked and their decisions overturned. State legislatures are entitled to a presumption of good faith, and federal judges have no business substituting their judgment for that of elected institutions, whether in redistricting or in any other area of constitutional law. Here is what you do right now. First, subscribe to Firearms Law Advisor and hit that notification bell immediately. Alabama's certiorari petition is coming, and the full merits ruling will have enormous implications for state sovereignty and Second Amendment cases. Second, smash that like button and share this video with every constitutionally minded person you know. Third, drop Firearms Law Advisor in the comments after subscribing. I personally find every single one and thank you directly. And tell me, which federal court do you think is most in need of the same kind of public rebuke the Supreme Court just delivered to Alabama's District Court? Stay informed, stay legal, stay free. I'm Michael from Firearms Law Advisor. See you in the next one when Alabama files its certiorari petition.